6 days of testimony from 23 witnesses, including the defendant, Christopher Schurr. Today, the defense arrested, and now the former Grand Rapids police officer's fate is in the hands of a Kent County jury. The options are second-degree murder, voluntary manslaughter, and not guilty.
To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case.
Judge Christina Mims gave jurors instructions before deliberations. The verdict must be unanimous. Jurors were dismissed at 12:41 this afternoon, but not before hearing the closing arguments from the prosecution and defense.
So what happens if it's not reasonable? It's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer that thinks that Patrick was trying to kill him based on what was here. So what does that mean? Defendant's guilty.
Prosecutor Chris Becker laid out some of the elements the jury should consider. This includes Leoya's death, saying as tragic as it was, he was still drunk driving and resisting police, but that, quote, doesn't mean he has to die. He says Schurr was on top of Patrick the entire time. Why did he have to use deadly force? His big takeaways was this killing justified and was it reasonable? Then the defense gave their closing remarks, saying the prosecution failed to make this point.
I like to equate it to you have a friend, family member who's on life support, and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit.
Defense attorney Matthew Borgula makes his final plea to jurors, telling them the prosecution must prove its second-degree murder case beyond a reasonable doubt. Borgula also says the prosecution must prove that Schurr was not in fear and his use of deadly force was unreasonable. According to Borgula, all the factors made in the defense's case point to a decision to use deadly force. He is now asking the jury to judge Schurr in his decision and not, quote, the noise around it. After he wrapped, the prosecution had their chance to rebuttal.
There's been no aggression, there's been nothing. Yeah, no punching, no kicking, no hitting, no anything. Think he was going to die because somebody had his taser. That's what's not reasonable about all this. And you're right.
Prosecutor Becker's last address to the jurors implores them to return with a guilty verdict to second-degree murder. He even said manslaughter is on the table. In the end, he recommends the jury review all the facts and think on what the threat really was. Now, the jury went home for the day and will resume deliberations tomorrow morning at 8:30. And joining us now is Professor Tracey Brame, the Associate Dean of Experiential Learning and Practice Preparation at Cooley Law School. Thank you for being here with us again today. Absolutely. Well, so first off, were you surprised jurors went home for the day and will continue deliberations tomorrow, or were you expecting that?
No, I was expecting that. This was a simple case, yet complicated, right? The ultimate issue around Officer Schurr's reasonableness is really going to take some thought and examination on the part of the jury. So I would have been surprised if they came back with a quick verdict. I think they really want to think about it, and, you know, they have three choices, right, for verdicts, and I think they want to review the evidence and try to get it right.
Yep, and they can look at video evidence, all of that.
Everything that was admitted at trial, right, should be back in the jury room with them and for their consideration.
I do want to mention this because after the jury left, Judge Christina Mims addressed a defense motion for a mistrial. An allegation came within the motion that she was rolling her eyes during some testimony. She denied that motion. What's the take on that?
I found that relatively interesting. So again, it's not unusual for the defense to file a motion for directed verdict or, you know, try to resolve the case short of sending it to the jury. But to file it based on her alleged demeanor or facial expressions, I thought was interesting. The only thing I can really think is that they are setting up their appeal options. Either they had to know that it was unlikely that Judge Mims was going to grant this motion, but in order to raise any issue on appeal, you first have to preserve it at the trial level. So I imagine if Officer Schurr is convicted, for example, they'll appeal, and they'll have a litany of issues upon which to appeal, and perhaps they wanted bias to be in play as one of those issues. But I thought it was an interesting move to accuse the judge of bias in that matter.
Obviously, we know Schurr is charged with second-degree murder, but jurors could look at a lesser charge like manslaughter.
Mm-hmm. Yes, they could. So, yes, so today we learned that the jury was going to be able to consider second-degree murder, which was the original charge, along with a lesser included offense of manslaughter. So they can consider, they can decide that Officer Schurr knew exactly what he was doing, that he intended to kill Patrick Loyola, and that he was justified in doing so, and that he, can be sentenced up to life in prison, or they could find him guilty of that lesser included manslaughter, which involves more of a crime of passion. Maybe he lost control, and before he could regain a control of his faculties and emotions, he acted, and that is more in the 10 to 15 year range. Involves a lower level of culpability, takes into account this kind of loss of control. The defense fought that, didn't want that option included, in part because it gives the jury really a compromise, right? So there might be some on the jury who want to convict on second degree, some who are uncomfortable with this. This gives kind of a middle ground to find him accountable, but maybe not at the second degree murder level.
And if they aren't able to reach a verdict, what happens then? So
if they aren't able to reach a verdict, Judge Mims will certainly encourage them to try their best to do so. They were carefully chosen. They've now heard 6 days of testimony. She will, if they come to her with difficulty deciding, she'll likely urge them to try. But if they just can't, then there'll be a hung jury, mistrial based on the hung jury, and they'll have to seat another jury and try it again.
As you've been watching the trial over the last few days, any impactful moments that stick out to you?
So to me, the very beginning of the trial, and then Officer Schurr's testimony, and just the beginning, I thought that the parties did a nice job of setting up the dichotomy between the prosecution case and the defense case, right? This jarring narrative of a person stopped for a traffic infraction that ends up being shot in the head versus this officer, right, in the battle of his life, scared and wondering why this person is fighting him so hard over a traffic violation. So I thought the parties did a good job of kind of really putting the right issue in front of the jury. And then, of course, we were all waiting to see whether Officer Schurr would testify, and he did. He had to, right, in a self-defense case, and that testimony was so impactful and so important for the jury to hear from him what he was feeling as they try to decide whether it was reasonable. Again, we see the impact of that from the defense counsel's motion, right, this afternoon, because the allegation was that the judge was rolling her eyes during Officer Schurr's testimony, and the impact that might have on the jury.
And last thing, thoughts on closing arguments today?
So again, just like opening statements, the parties told us what we would hear over the course of the 6 days, and they really delivered for the most part. So the closing arguments, both sides, again, I thought did a good job of presenting to the jury their version of the case. And so, for example, we've heard a lot about the totality of the circumstances, and the defense is urging the jury to concentrate on that 2 to 3 minute struggle that Officer Schurr was in, and what he was feeling and thinking in that moment, whereas the prosecution includes in its totality of circumstances from the moment that Mr. Loyola was stopped, right, and whether he was stopped properly, et cetera. So I thought they both really laid out their case, laid out their narratives, and gave the jury, kind of options to look at within the law that they heard from the judge. So we'll see. I think it's going to be a close case.
All right. Thank you, Tracey, for being here with us. So stay with News 8 for continuing coverage of the Schurr trial. We'll take you live to the courtroom as soon as a decision is made on air and online at woodtv.com and on Wood TV Plus.